Hello all, hope you are doing well. Those who are going to apply UGC NET in law, there is one subject of jurisprudence. In this jurisprudence subject, there is sub-points: nature, source of law, positivism, natural law theory, sociological jurisprudence, and so on. So in this video, I'll try to cover legal theory, nature and sources of law, positivism. So let's start. For the jurisprudence. In jurisprudence, there are so many theories and law. So the theories and law, there are some common points, like in this, the first point, based on hypothesis, second, can be used to make prediction, and third, can be revised. But the theory in jurisprudence or legal theory, we can say, in the is the theoretical study of law, which uh, which provide a deeper understanding and deeper knowledge of legal reasoning and analogy, as well as legal system, legal institutions, and the role of law in society. Whereas the law is concerned, that the law means justice, morality, reason, the order, and of course the from the which point of view of the society. Law also means the rules of court, decree, judgment, order of courts, injunctions, from the all this point of view. So when the question asks maybe theory and the law, you should be understand this. The main common points are the based on hypothesis, can be used to make predictions, and can be revised. Whereas the law is concerned, law summarize a set of observation about natural phenomenon. Whereas the theory explain why natural phenomenon occur. Now we can move the legal theory. See, for the legal theory, I put it here some randomly question like who coined the term of legal theory, who is the father of jurisprudence. So, who coined the term of legal theory? The answer is Dr. W. Friedman in 1995. But the first question and the last second question explain Friedman legal theory. See, sometime one question, there are two questions asked in a one point of view. Like here, I put here who coined the legal term legal theory, Friedman, and explain Friedman legal theory. So if they explain Friedman legal theory, here the answer will be that in the sense as an evaluative and normative study of the concept of law and its this relationship with morality and justice which the law subserves. Okay, who is the father of jurisprudence? The answer is Bentham. Bentham is a known father of jurisprudence and was the first one to analyze what is law. How many branches of jurisprudence are there? Three branches are there, like analytical, sociological, and theoretical. What is the purpose of legal theory? So purpose is that to provide a backdrop to the legal, moral, philosophical, and societal influences impacting the legal English legal system. What is the difference between law and jurisprudence? So law is the body of rules and standard issued by a government or to be applied by court, whereas the jurisprudence is legal, the philosophy, science, and study of law, and decisions based on the interpretation thereof. Then the Friedman, which has explained, see the year is Friedman 1945. Please keep in this remember. What is the jurisprudential theory? The last one question is it is the theoretical study of law and deep study and in-depth knowledge, deeper understanding of legal reasoning, analogy, legal systems and legal institution and the role of society in law, of course. The nature and source of law. See, I put it here for five points like nature of law. Law consists of system of rules, standard and procedure that social institution create and apply. First point, as a simple definition would be misleading because law is so diverse and complex. The second is Generally, the recognition rules and principles that govern and regulate social conduct and the observance of which can be enforced in law. Third is also the person in respect to one another and in respect to the entire social group or society. Affects every aspect of our lives and should be followed by everyone concerned. But sometimes a little bit confused about the nature of law. So see, you please remember some trick in jurisprudence, like it is followed by everyone concerned. The fifth point is everyone concerned. If there is everyone concerned, means you and me, definitely you and me applicable to rules, the standard, the procedure, and it's apply. You get the definition of nature of law. Fine. Then concept of natural law. So of course it is concept of natural law is to independently of human will. It is a natural because it is not humanly created. It is a law which is inherent in the nature of man and is independent of conventions, legislations, or any other institutional advice. Natural law is a philosophy of nature because it is a certain rights are there, value is also there, and are inherent by virtue of human nature and universally cognizable through human reasons. Historical point of view, the use of reason to analyze both social and personal human value to deduce binding rules of moral behavior. Meaning of sources of law. Meaning of sources of law which indicating the factors that have been influenced by the development of the law but by themselves not recognized as law. Themselves not recognized by law because it is a religious practices, local customs, beliefs, opinion of jurists and all. Place where the law can be found, of course the statute, law report, textbook, journal, decision of courts, etc. Legal source, legal rules that makes the law, written or unwritten. Because in India is somewhere written, or we can say the other country has not written. So there are some, like legal sources are something, somewhere is a little bit different, we can say. But where is the question came like sources of law? It will be immediately you must be understand, yes, it is something development of the law, but by themselves not recognized as law. That is the source. I put it here some two diagrams so it will be very understandable sources of law and it will be very easy to remember that law, because you can see here that the law is divided into two, that is one international and the national, then public and the private. Then when we say public, so it is only constitutional, administrative and criminal. When we say the private, then the law of person, the law of property, law of obligation, conflicts of law and so on. So the law has a national as well as international. Whereas sources of Indian law we can consider the source is the custom, tradition, precedent, legislation. Then again there is a division of custom, then legal and convention. Again the legal, then local and general. The precedent, binding precedent, possessive precedent, legislation, primary and the secondary. So these are our sources of law. Sometimes images and the diagram is very easy and like very easy to remember. So it's easy for you to remember this two diagram, sources of law and all. Then sources of law is a formal sources and material sources. Formal sources are sources from which law derive its force and validity, its force and its validity. Whereas material sources is law derives not its validity but the matter of which it is composed. It is composed. It's not validity. But then historical sources and again there is a legal sources in material sources. So legal, when the legal point is, of course there is a enacted law, case law, customary law, convention law, all are there in the legal sources. Whereas historical sources, that is like a jurist writing, foreign decision, like our Indian decision, like judgments, that no recognition, authoritative, that is sources of law. Then we move for the jurisprudence of legal theory. See that there are so many points which is covered in jurisprudence of legal theory, like sociology of law, critical legal studies, formation, realism, programmatism, Marxism, legal positivism, contemporary theory, utilitarian theory, historical sources, and natural law. So all points covered in the jurisprudence of legal theory. Then positivism. Positivism is a Austin Combs which coined the term of positivism for the first time in jurisprudence, and that sociology can be developed on the line of natural sciences. That positivists believe that society is the part of nature. Society is the part of nature, and hence whatever the rules, the law, and the theory it is applicable on nature is equally applicable on society. That the first is society is the part of the nature according to Auguste Comte. Then positivism. See, when the question asks like positivism, it's main who defined or something, then you must be remember that Professor H.L. Hartz has given a meaning of positivism. Law is the command of human being. Law is at law is not to be derived from, nor there is to be any relationship between law and other inquiries. That legal system is a closed logical system. No external aspect can be allowed to be considered in law. As in constitution, the case like A.K. Gopalan versus State of Maharashtra, it's a landmark case. You can go through that, you will get a very good idea for that. Law is a matter of fact, the fact considered in law, and it can be defended or justified, unlike moral statement like a capital punishment. The Augustine Comte is the founding father of sociology. The founding father of sociology. But I explained in earlier before one or two slide like positivism. So definitely something in a doubt. So please don't create any doubt, because see the last point, fifth point is mentioned positivism. So Auguste Comte also is the founding father of sociology. In this sociology, definition of sociology, it is divided into 5 points, and that 5 points, first one is the classification and ordering of social sciences, the coining of the term sociology, the law of three stages, the plan of social reconstruction, and positivism. So here the fifth point is a positivism, because it's a socializing sociology aspects. That's the positivism. But in this positivism theory, there are so many, criticism also. Like positivism has received a wide range. The first is that attacking not only its epistemological and ontological basis, but it's a claim it has been responsible for many social problems. Because the idea that knowledge is objective and value free has been defeated on both theoretical and empirical ground. Like the mechanical view of science, that logical positivism is through to promote, where interpretation, values, ethics, and expression, and so on, which is, its uncertainty, its ambiguity, and because of that, have no place. So the positivism also face some criticism point, but with legal positivism, in short, if we want to remember, so it is a point like law imposed by man and society. Law imposed by man on society. Rejection of God and morality as being essential for a legal system. This is a clear cut definition that it's easy to remember. Law imposed by man and on society, rejection of God and morality as being essential for a legal system. Now, if the legal positivism is concerned, we remember here for the Augustine Comte, Jeremy Bentham, Hans Kelsen, and John Austin. And what they mention here, the three-stage development of humans law, the social science, sociology, and scientific method. Whereas Bentham statified that natural law, development of unique language, complex theoretical legal system. John Austin, law based on obedience and sovereignty with a command theory, whereas Kelson specified is a Grun norm theory, social norms theory. So legal positivism, we have here 3 to 4 main authors points. Now there are again some questions I put it here for the important point of this three: positivism, natural and sources of law. That legal positivism directly clash with theory? The answer is natural law theory. Who amongst the following scholars is not a proponent of legal positivism? The answer is, this is little bit tricky question which I put it here. Who among the following scholar is not a proponent of legal theory? So sometime like Austin, Bentham, like Hart's, all these points are there, but the question is I framed in a negative form. So you please keep in mind this is not means its answer is Ronald Dworkin. Ronald Dworkin is the scholar who not a proponent of legal positivism. Okay, what is the fundamental problem in finding an analogy of Austin political sovereign in Indian Constitution? See the Indian Constitution and Austin. So in Indian Constitution, Austin sovereign, it's Austin is a political sovereign in turns, and does not himself like habitual obey like some other persons. It is like Austin political sovereign in turn, like the answer will be political sovereign. And we can say we the people, the word is we the people as a political sovereign. Okay, we the people as a political sovereign is to diffuse a body to locate sovereignty with certainty. So the answer is Austin and Indian Constitution. This is two related questions. So the answer will be we the people as a political sovereign. Okay. Now next is identify the scholar like who describe law as a tool as a mean of harmonious social interests that may be in conflict. So maybe that there are so many options just I mentioned Bentham, these that, but the harmonious construction, harmonious social instruction, the word is here in any question. Please keep it in mind. The answer is Roscoe-Point theory. Those who did LLM, so there is the one topic in for the Roscoe-Point theory. So I think it's easy to it's easy to remember them only. The point of conflict between natural law theorists and positivist theories, which is the point is very conflict with natural law theories and this. The conflict is that you know, moral propositions that which is constitute a superior law, and of course the failure to confer to such a superior law deprive ordinary positive law of all the legality. So the answer will be moral propositions or the which constitute a superior law. Then what is the problem with defining law as a command? The law as a command. What is the problem? The problem is the obligation. The problem is the obligation which are sometime enter into voluntarily by parties and the law and does not mandate them to do so. This is the problem with defining law as a command. So thank you so much for watching. All the best. Please like and subscribe, hit notification bell so you would know the next video. Thank you so much all for watching. All the best. Bye bye.